The Americans with Disabilities Act, ADA, prohibits discrimination against applicants and employees who are qualified individuals with a disability, while workers' compensation laws provide a payment of compensation and rehabilitation for workplace injuries and minimize employer liability. This video will help you understand the relationship between the ADA and workers' compensation.
The definition of a disability and eligibility differs between the ADA and workers' compensation. Workers' compensation laws are established at the state, territory, or district level and will differ, while the ADA is a federal statute and applies across all states, territories, and districts. Even if an employee with an occupational injury has a disability as defined by workers' compensation statute, there may be a question as to whether or not they have a disability for ADA purposes.
The ADA Amendments Act of 2008 expanded the definition of disability, affirming that someone does not have to be severely limited in order to be covered. Episodic conditions and those in remission are also covered.
Thus, an employer should assume that someone who has a disability-related occupational injury that limits them in performing at least one major life activity will meet the definition of disability under the ADA unless the limitation is minor or transient in nature, common cold, flu, uncomplicated bone fractures, etc.
Determination under workers' compensation that someone has a permanent disability or is totally disabled does not necessarily mean that the individual is unable to work. Workers' compensation laws use different standards than the ADA to determine the ability to work. The ADA places the focus on whether or not the individual is able to perform the essential functions of a position with or without reasonable accommodation.
It is important that an employer does not simply assign someone with a work injury to a different job without first assessing whether the employee can perform the essential functions of the pre-injury job with or without accommodation in order to meet their obligations under the ADA. The ADA prohibits an employer from requiring that an employee with a disability-related injury be able to return to full duty before allowing them to return to work. In addition, the employer may not refuse to return to work an employee who is able to perform the essential functions of the job with or without a reasonable accommodation, unless they can show that returning the person to the position poses a direct threat. The ADA does not require an employer to create a light-duty position as a form of reasonable accommodation. However, an employer may recognize a special obligation arising out of the employment relationship to create a light-duty position for an employee when they have been injured on the job and are unable to perform their regular job duties.
More information regarding the interplay of the ADA and workers' compensation can be found on the EEOC website.